As I was asked to come here to speak about global white supremacy, the legal effects of it, one of the things that you do in the courtroom is that you bring on your exhibits to prove your case. And so I reached out for my exhibit. Exhibit A was in Washington, D.C., and Exhibit B was in Oklahoma. And somehow or another, Rochester had to serve Jack Bennett today, and Beulah had to do some cooking out in Oklahoma. So the legal effects of white supremacy are not here. As a matter of fact, Judge Tom was scheduled to go on the Supreme Court in November, but somebody from the porno shop called him up and said, if you wait until November to go on, you may not be able to sit on a case that's going to deal with the future of pornography. And so Clarence was sworn in today to ensure that pornography lives on. When you began to understand the white man, and you also begin to understand Clarence, one of the things you have to do is this. Clarence said at his swearing in with the president last week that his best friend was his wife. And that's important. We won't have a chance to get into that tonight. Maybe next week we talk about Satanism. This topic's sort of limited tonight to something else. But in saying that, I think that we did not focus on the right person. These hearings should not have been about Clarence. They should have been about Clarence's wife and what she is into. I said a couple weeks ago, before these hearings got started, that this hearing was about homosexuality and lesbianism. And I just only add to that the hearing was really about homosexuality, lesbianism, and Satanism. And when you began to understand that she was a member of this organization called CAN, Cult Awareness Network, misleading term, as all whitey's terms are. But I would suggest between here and next week that you do a little research on CAN, and we'll get into Satanism next week. I'll stick to my topic this week. But in listening to the other speakers, what was interesting was that Professor Wilson talked about Columbus and not focusing on Columbus, but focusing on what was behind Columbus. Right. And we have a tendency to focus on the wrong thing. And we therefore miss the point. We get a false reading of what is happening. And so when we begin to focus on the white man, what we really have to focus on is the white man's best friend. I won't get into that this week. But I think we all know who the white man's best friend. And in understanding the white man's best friend, we can begin to understand the legal system that Whitey has put together. Because there's a relationship in that, but I will leave that to my lecture on biology. But I won't get into that tonight. I'll leave that because we deal with the legal aspects tonight. But in order to understand the legal aspect, you have to understand so many other things. You know, one of the things about really being a great lawyer is having a mastery of so many subjects. You know, and sometimes you find yourself in a medical library, sometimes you deal with psychology and so many other things. But What we're going to focus in on tonight, which I think is extremely important, and the subject that I am particularly interested in now, is the whole notion of psycholinguistics. We must begin to call things by their proper name and begin to make an appropriate analysis of that. And so we have to begin to look at the legal system much differently than we have looked at it in the past. Now, when we look at the legal system, it is my opinion that there are two symbols that are important to understand the legal system. One is the scales of justice, which a lot of people don't understand. The legal system to the white man is like a boxing match. It's a contest. And the first thing the boxers have to do is get on the scales. Well, that's what happens in court. When you go in the courtroom, one of the plaintiff and the other the defendant, they said, well, Mr. Plaintiff, get on the scales. And you say, hey, wait a minute. I thought I was here for justice. But you see, that's what those scales are for, to weigh you in. And the one that is weighed as the heavyweight outweighs the lightweight in terms of economic power. And that is the reason why we are always losing, because when we go in there and they weigh us in, we are always being outweighed. You see, because when the man rules against us, Whitey said, well, I had to rule against you because that was a heavyweight and you a lightweight. And you ought to be glad that I ruled against you, because if I had to rule against you, you had to get in that fight with him and you would have really gotten whipped. So you ought to be thankful that I ruled in your favor so you wouldn't have to get whipped by this heavyweight. You see, it has nothing to do with what your case is about. It has something to do with the power that you bring to the courtroom as opposed to the power that your opposition bring, and the scales of justice are used to determine that. You see, I don't know what we thought these scales were for. I mean, the white man don't hide his stuff. Negroes just look at stuff and start hallucinating and imagining something else. But this cracker puts it right out there. You see the scale and he's telling you, I'm getting ready to weigh something. I mean, it's right there. I don't know why we get confused about what this man put right out there. Negroes thought, well, it's justice, I just gonna do right, and I know I'm right, and I know everything will work out all right. You know what I mean? It ain't got nothing to do with that at all. It has nothing to do with that at all. So we have to begin to improve our vision and deal with our language. You see, we got to make sure that our eyes are operating on 2020. And in fact, they have not been. Dr. Clark has lost his sight, but has greater vision than anybody in this room. Let us not lose sight of that. The other thing about the American legal system and legal systems in all European countries, but particularly here, is that the other great symbol of American justice and European justice, but particularly American justice, is the eagle. You see, that symbolizes his judicial system, because the eagle is a scavenger. And that's what the white man's law is. It's a scavenger. You see, government does not produce anything. And, when we look at someone who has a Rolls Royce, a Mercedes, lives in a mansion, and has $6 or $7 million stashed around, people say, well, man, what do you do? And then the guy said, well, I don't do anything. I don't work. And then people say, well, man, that guy must be in the drug trade. He must be doing something illegal. Well, you see, that's the way government is. You have a city government that has a $29 billion budget and does no work. It doesn't produce anything. So if it does not produce anything, and it has $29 billion a year to operate with, then you must imagine that this government is engaged in criminal activity, because that's the only way that it could function. And so, when you began to understand this, and this is psychological, and we have to deal with this on another day, is that you must, in order to understand European institutions, you must understand the criminal mind. You must understand the criminal mind, because all of his history indicates criminality, and everything that he has acquired has been as a result of criminality. And I remember last year I have a Bill of Rights speech that I made at Columbia last year, and Roy, those have been asking me to give that here at some point in terms of dealing with the Bill of Rights. But just as a preview, which I won't have time to do tonight, is that the Constitution was written by the criminal mind. I mean, if you read this document, it becomes very clear that it is a criminal document. And you see, when it gets to the amendments, and it talks about the right to a trial by a jury of your peers, who but a criminal will write something like that in a document? All right, you see, when these bad boys sat down, you know, and everybody said, well, man, you know, we may be getting ourselves in a little trouble here. You know, I mean, we're in some bad stuff. So the signer said, well, let us make sure that we have a trial by a jury of our peers. You see, if we're going to be tried, let other gangsters and other criminals sit in the jury box. You see, and when you begin to understand that the Fifth Amendment says you have a right to be quiet. Now, who but a criminal would be informing other criminals to be quiet? You see, so when you begin to study this document, I can prove to you on a criminal mind lecture that it was criminals who put this document together to protect criminals and criminality. But what I want to talk about is 3 quick points, and then I'll be through for tonight, but it has to require a lot of expansion because these are very interesting subjects. And, you know, when I went through law school, like everybody else, you were not really taught the law. And I look at about 99% of most lawyers now, and they have absolutely no idea about the law. And when they go into courtrooms, they actually go into courtroom arguing for their continued oppression, because they have no idea of what they're arguing about. And, you know, the one thing in terms of my career is that I say this all the time because it's true. There was no better trial lawyer in America than me. I mean, there's no question about that. But the reason why that was so was not because I was a great genius. There was nobody who studied law and legal institutions more than I did. I studied this 24 hours a day because I understood that I had been miseducated in the law, and I had to work this out for myself in order for me to be effective in representing black people, because the entire law school education was never directed toward representing black people. So when I got out, and I came up with these new strategies and techniques, the white boy did not know how to deal with it, because the whitey had never been taught that himself. So when I was going in a courtroom playing guerrilla warfare and military science, nobody understood what was going on. All right? But when we began to look at certain concepts, and these are very important, there is no such thing as a constitutional right. All right? And you know, most lawyers use that word, but they don't know what they're talking about. And you know you're in trouble when you get a Negro up there talking about your constitutional rights. You may well get ready to go to jail right then. All right? All right? When they start talking about your constitutional rights, Jack, you better get ready to boogie. All right? You know, because after reading everything in the law, I realized there was only one case that was relevant, and the white man has printed over millions of cases. And that one was Dred Scott, and that's the only case I ever used. And I would whip people on Dred Scott. You know, everybody will be reading 100 cases, I just get Dred Scott, you know, and go in the courtroom with Dred Scott and win on that concept, because it defined us properly in the American judicial system. And that's what's important, is appropriate definitions. You see, if you misdefine yourself, you've already lost the battle. You know, just on misdefinition. So misdefinition is very key, and phrasing the right question is very key. You see, and that's another problem that we have. We never phrase the right question. We never phrase the right issue, and we always lose. I can tell you whether you're going to win or lose by the way you phrase your issues. And so all I have to do is say, what's your issue? If you phrase it wrong, you lost. Wow. And you know, that happens so many times. I've come to the slave many times, predicted things, but I predicted them scientifically because I knew that you were misdefining your issues, which is a subject into itself that we won't have time tonight to go into. But going back, it is no such thing as constitutional rights. What it is constitutional authority. You see, it's not a constitutional right, it's constitutional authority. And when you read the Constitution appropriately, then you will know that there is no constitutional right. Each provision, each amendment does not talk about the rights of the people. That's only in the preamble. You know, everybody reads the preamble and then that's it. But if you analyze the document, it does not talk about rights, it's talk about authority. For example, if you look at for example, I'm just going to read these so you can see them real quick. The Third Amendment reads like this: no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Let me read that again. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Now that does not say that you have a right not to have soldiers in your house. It says that the government has the authority to place soldiers in your house. You see, it doesn't say what you think it says. So when you say, well, I have a right, you know, just like people say, well, I have a right not to be sexually harassed. Well, that is not so in the workplace in America. You know, white people have a right, or they are given a license to harass you sexually in the workplace. And the reason why you know that they have that right is because they are saying that we got to pass a statute. Now, what that statute does is say, and this is what all statutes do, it says not that you don't have a right to sexually harass, it says that you have a right to sexually harass up to a certain point. You see? So it's never you don't have the right. So when you say, well, I'm being sexually harassed. Well, the Supreme Court has only ruled once on this, and this was a case where the guy had raped this woman repeatedly on the job, and had done a lot of other funny things. And so they said, well, that may reach the level of sexual harassment. But they only said that without Clarence on the bench. All right? Now, Clarence now is on the bench, Souter is on the bench, Thurgood is off the bench, Brennan is off the bench, and so raping a woman under the Thomas Supreme Court may be all right. You see, but in any event, sexual harassment up to a point is okay. So when you look at the white man's law, it does not say what you say it says. You know, but your interpretation of the law is really a reflection of your faith in him. Right. You see, and the more faith that you have in him, the more of an inability of you to see what the law really says. You know, and you can sit down with lawyers and they will misconstruct what the statute actually says because of their underlying faith in the man himself. But if you don't know who the man is, you're going to mystify what his law actually says. Another amendment, just be very quickly. The Fourth Amendment says the right of the people to be secure in their persons, home, papers, and effects against unreasonable searches and seizures shall not be violated. Now that doesn't say the government can't search your house. Right. And they don't define what is an unreasonable search. Right. You see, so that's the authority to search your house. It's not your right not to have your house searched. So you have to begin to understand the white man's way of expressing himself before we can really get a lot deeper.